But I know you're thinking the same thing I'm thinking, all right? This kind of reminds you of another trial that was covered a few years ago that ended in a very surprising manner. Down in Orlando, Florida, you may recall it. Let's bring in our think tank tonight. So I've got some questions for them. Joining us in New York, former senior homicide prosecutor Bernarda Villalona is with us. In Denver, Colorado, criminal defense attorney Jeffrey Wolf. And in Los Angeles, California, former federal prosecutor Nima Rahmani is back with us. Great to see everyone again. You know this story it reminds me of, that woman down in Orlando, Florida, with a daughter named Kaylee Marie. And I want to ask you this question off the top. Like, what is the defense going to be here? In that case, they pointed the finger at the defendant's father, the child's grandfather. Do you think you're going to see something like that happen in this trial, Bernarda, where they're going to go after a family member?
Well, if I'm not mistaken, Vinny, I believe that the body was actually found on the property of a family member. So that does leave an opening for this woman to actually try to point the finger at another family member. What I'm curious to know and to get back is the results of the autopsy. What was the cause of death of this toddler, of this child?
You know, Jeffrey Wolf, I always get suspicious of mothers when their tiny little children go missing and they don't report them missing. It happened down in Orlando, and somehow, some way, 12 people from Pinellas County, Florida said, no big deal. I think it's a big deal. I think it's a real big deal. What do you think, Jeffrey? Is that an issue that you think may resonate with a jury when it's a trial of the mother and she does nothing when the child is missing for 2 months?
Well, you would sure think so, Vinny, and I think that's why she's the one being charged here, because we don't have a lot of information of how they actually tied her to it. They may have some pretty compelling evidence that does that, but I think they have a pretty good way to hang their hat on these crocodile tears that you see for a child that you have missing for 2 months. At 15 months old, that's a large portion of that child's life that the mother is reporting nothing. And it's shocking. It shocks the conscience. I know that if my own children were missing, it would be a matter of seconds, not a matter of months, before I got somebody involved. And I think that a jury has a really tough time with that. But I also agree that because they found the body at a family member's house and because they have the car with the mom, there is going to be a bit of a finger pointing going on in this family. And God knows whether they were in cahoots or what was going on.
All right, Nima Rahmani, you're the former federal prosecutor. I trust you. How do we avoid a repeat of what happened down in Orlando in this case? What do prosecutors have to do?
Yeah, Vinny, this isn't Casey Anthony. This is a mother.
You said it. I tried to do the segment without saying it, and he says it. All right, go ahead. That's fine. I'm
not going to jinx this case. This is an entirely separate case. You know, you have a mother here, as you said, didn't report for 2 months. She gave not just one, but two conflicting stories, right? First, she was with dad, right? Evelyn's father, Perry. Then she was with her mom out at some campsite in Virginia. So two different stories. Like, I understand the family here has a significant criminal history, parents, grandparents, but this is a case about mom. She is going to be found guilty. There's a lot of evidence in this case, and frankly, she's hung herself by all the inconsistent statements she's not only given law enforcement, but the local media down there in Tennessee.
Well, here's the problem, Nima and Bernarda, is that, yeah, I saw that happen in Orlando. Remember Zanny the nanny? That's who had Kaylee Marie. Do you remember when police said, well, where do you work? And she said, Universal. And she goes with two police officers over to Universal and she's almost walking into the office and then finally admits that I don't work there. So lies, for some reason, don't mean anything to jurors, Bernarda. Why does someone who lies about everything involving the death of their own child get a benefit of the doubt at the end of the day? All right, wait. Let's move on to this case. So how do you avoid that, Bernarda? That's really the question.
Well, Vinny, first off, we're dealing with a different jurisdiction. So that was Florida when we were dealing with all those inconsistencies, and yet that woman was not found guilty. Here we're dealing with Tennessee. We're dealing with a different jury pool, which is completely different than the mindset of people in Florida. So what they will have to do, the prosecution will have to do is, one, make sure that she does not look sympathetic to the jury. Make sure that you label her what she is, which is a killer, a child killer from the very beginning. Make that the narrative. The problem is with Florida is that that woman was such a party girl and there were so many issues that was going on with her that they kept focusing on that as opposed to the actual crime and how she was negligent and not paying any attention to where her daughter was. Here we have from the very beginning, this woman, this child killer, this horrible person who from the very beginning is lying and never ever, with 2 months gone by, reports her child, her blood missing.
That's a great argument. You can tell she's done this, folks. You can tell that she's done this for real and very successfully. All right, Jeffrey Wolf, I want you to listen to today's hearing, because there was a hearing today, and pay close attention to the defendant, Megan Boswell, because she speaks up. And I want everyone to remember, she was 18 when little baby Evelyn died. She's still only 19 years old. Let's take a listen.
All right, Ms. Boswell, raise your right hand. You solemnly swear or affirm testimony about to give is the truth, the whole truth, and nothing but the truth, ma'am?
Yes, Your Honor.
All right, go ahead and tell me whatever you think you need to tell me.
Mr. Sproles and I have resolved any issues I had with his representation, Your Honor.
All right, so you're good to go forward?
Yes, sir.
All right. One of the main objectives of today's hearing was to find out if the state was prepared to file notice to seek enhanced punishment.
We have filed a notice to seek a sentence of imprisonment for life without the possibility of parole, and the aggravating factor is 39-13204I1. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older.
Where are we in the discovery process?
Judge, we had announced at the last hearing that the state has provided us with the discovery responses, and it's considerable. We have been able to work through roughly about half of the information here, but we're still trudging through that.
Do I need to set a motions hearing date or a motions deadline? I kind of feel like Mr. Sproles probably needs to get all the discovery before he can decide what motions need to be filed, and that needs to be done before we just blindly set a trial date.
I agree with that, Judge. I think he needs to see everything before he can evaluate what or if any motions he files.
General, when do you anticipate having the rest of this information to Mr. Sproles?
Well, some of it will be relatively immediately, and some of it will require some forensic analysis. And Ms. Nelson, General Nelson thinks it'll be at least 8 weeks, and I think it might be a little further than that out.
All right, so they'll be back in court in May. But Jeffrey Wolf, in the beginning there, Megan Boswell spoke, and the backstory is there was some back and forth between her and her attorney about trial strategy. And I was just shocked by that, and I don't know if you are, because it's a 19-year-old, and even the way she spoke, she seems to be very much aware and participating and a level of sophistication as a criminal defendant that I wasn't expecting from this 19-year-old.
Well, I'll tell you this, Vinny, and I can speak to this a little bit as the only career defense attorney on this panel. She is doing herself a very good service by being involved in her defense. It's something that I always wish more of my clients would do. I know that a lot of people will say they don't want to fight with their client, they don't want to have their client give them their opinion and things like that. But at the end of the day, this is this young woman's life. That is what is hanging in the balance. No one else's, not her lawyers, not the prosecutors, not the judges. It is her life hanging in the balance. I like it when my clients get involved in that process, and I like that she was able to resolve the issues with her lawyer, because we do see that happen from time to time. And I think it's important to state here, just to respond to what we were saying right before this video, is that we can throw the words child killer around, and we can hoot and we can holler about all of that. This is an 18-year-old kid, okay? And as a defense attorney, it is almost offensive to just lambast her and ask why she gets the benefit of the doubt. She gets it because we're all innocent until proven guilty in this country. That still works, right?
Oh, absolutely. But Bernard was taking us inside the courtroom as to what the arguments are going to be made. And I thank you, Jeffrey, for pointing that out. We're not convicting anyone on this show. We are saying what prosecutors will argue in court, from experienced prosecutors that we have, and that's why we bring in great defense attorneys as well, Jeffrey. But I appreciate that in case anyone misinterpreted what was happening there. We would never convict someone before the evidence is in and we've seen it. But let's talk about something else that was talked about today, which is life without the possibility of parole. It's not a death penalty case, but it's still life without parole for an 18-year-old. Nima Rahmani, would you be comfortable as a prosecutor trying to send an 18-year-old who's now 19 away for the rest of her life?
No question, Vinny. If she's convicted of murdering a 1-year-old baby, she should spend the rest of her life in prison. And in fact, prosecutors shouldn't have taken the death penalty off the table. That's significant leverage in this case because now you've boxed yourself in as a prosecutor. You can't offer a deal in this type of case because it's a life case. But had you had that potential death sentence, you could have potentially bargained down and had her plead to life without the possibility of parole. Now you can't, and now as a prosecutor, you have no leverage, you have no hammer, and you're stuck trying this case.
All right, and we will be covering it, folks. We'll stay on top of this one. Again, in May, they'll be back in court. We'll have more updates then. All right, when we come back, not a mother, but a stepmother. Letecia Stauch is her name. She's accused of murdering her stepson, an 11-year-old little boy. And this is a heartbreaking case, but this is another defendant that has a bunch of stories to tell. We'll talk about it when we return. We've got big news tonight in the case involving the death of 11-year-old Gannon Stauch. This was a little boy who went missing out of Colorado Springs, Colorado. Eventually, his remains were found in Florida. His stepmother charged with his murder. But this case has kind of been just, nothing's been happening for months because of the mental condition of Letecia Stauch, the stepmother. Well, all of that has now changed. Julie Grant has more for us.
Letecia Stauch, the woman accused of murdering her 11-year-old stepson, has again been deemed competent to stand trial. Stauch's case was on pause, pending a review of her initial competency evaluation conducted by the state hospital last year. That evaluation found her competent, but the defense moved for an independent assessment with a doctor of their choosing. This week, the court deemed Stauch competent after the psychiatrist retained by the defense came to the same conclusion as the state's examiner. That means after more than 6 months of delay, Stauch's case is back on track. Letecia Stauch reported her stepson Gannon missing from his Colorado Springs home on January 27, 2020. Stauch told investigators that Gannon never returned home after playing with his friends. Police opened a missing person investigation while the community took action to try to bring Gannon home.
Whatever we could do just to show them that we're thinking of them and, they're in our thoughts and prayers.
Investigators examined countless phone, GPS, and home security records and a surveillance video from a neighbor's home.
It just didn't seem right the way she was talking. Okay. If my child is missing, I'm gonna face the camera and talk to you. That you see the pain in my face.
Search warrants uncovered blood matching Gannon's DNA in his room and in the garage near Letecia's car. And the evidence was enough for an arrest. 2 weeks later, Gannon's remains were found in Florida, about 15 miles north of Pensacola. Letecia Stauch is presumed innocent, and according to the arrest affidavit, she has a story. She told investigators Gannon was abducted by a Hispanic man named Eduardo, who took Gannon at gunpoint after sexually assaulting Letecia inside the family's home. That's a story investigators don't believe. Now that Letecia Stauch is competent to stand trial, she's scheduled for a 2-day preliminary hearing on March 11th and 12th.
All right, the prelim is coming up. She's now competent to stand trial, but this is one of those things. We've seen her in court a few times, but we really haven't heard much from her. but Letecia Stauch gave one interview to a local TV station in Colorado Springs, KKTV, on January 31st last year. Her stepson Gannon was still missing at the time. Now, in the interview, she has her back turned to the camera. Just her hair is showing as she's speaking with the KKTV reporter. She talks about various issues in the interview, but we've really zeroed in on the portion that speaks to the issues that fall under the umbrella of competency, understanding the nature of the proceedings and being able to assist in one's own defense. Here, she claims her constitutional rights were violated when she answered questions from detectives.
I asked for an attorney during the interview, and I was denied that by them. I was held because they were blocking the door, and I was told I couldn't leave, and that if I would have touched them, they would have probably, said I still wasn't complying, or said I was, trying to run away or something. But during the interview, I asked several times, could I stop the interview? Could I get an attorney? Could I stop the interview? Could I get an attorney? I was denied. I was told I couldn't get nothing to drink. I couldn't go to the bathroom. I mean, it was continuously that my constitutional rights were violated.
So there, she clearly seems like she knows what's going on, right? But that is not relevant because competency is about what she's like now, and they have now found that she is competent. So this prelim will go forward. Let's bring back in our think tank and begin, of course, in Colorado with Jeffrey Wolf. So here's the question. We've got the preliminary hearing coming up. She's now competent. When you have a client like that who's in and out of competency, I guess it's always an issue, always will be, but how difficult is it to represent someone like that? I mean, she's already told a couple different stories. How do you handle all that?
Well, it's going to be incredibly difficult. We have a really good public defender's office here, and she's represented very well by her attorneys down there. I happen to know one of them, and she's a very passionate attorney, and I guarantee they didn't take the issue of competency lightly, especially with the charges she's facing. She could sit in a mental health facility for the rest of her life if found incompetent on charges like this. And so for them, it's going to be incredibly difficult to deal with a client who has a transient mental health issue that comes and goes, which could be exactly what's going on here and could be the reason that they're having so much difficulty. Throw COVID into that, where the Colorado Springs jail was just sued to high heaven for not giving masks to the inmates and having one of the largest COVID outbreaks in our state. And it's hard to even get in there and have a face-to-face conversation with her. So they're on video chats and things along those lines. It is going to be a really tough hill to climb for some really good lawyers out here.
Yeah, Neem, I think the biggest hill to climb is going to be getting around the different stories. So as a prosecutor, do you prepare for the, I think his name was Edgardo, the rapist story, or do you prepare for he went over to a friend's house?
As a prosecutor, you love those inconsistent stories, right? I mean, the Hispanic rapist is just absurd and offensive. But even, going to your friend's house, from just listening to the prosecutors in this case, in Colorado, I mean, it's not a death penalty state, so that's not an option. But they are very confident that they're going to try this case. They're going to ask for life. They're not going to give any discounts because they have all the evidence that they need. They have the DNA. They have the blood. They know how this poor 11-year-old was killed. So I expect and they expect that this case is going to move forward. And those inconsistent statements are going to be the nail in our coffin.
Bernardo, this is a complicated case for a prosecutor, though, because of there's many different scenes. There's the house. Then there's where Gannon's body was originally supposed to be disposed of in Colorado. Then we know it was recovered down in Pace, Florida, and she was arrested in South Carolina. So there's a lot of evidence, a lot of things you got to organize well in this case, and it's got to all make sense to the jury.
So, Vinny, a case like this, you have a lot of moving pieces. So you're going to deal with a lot of witnesses because obviously you're going to have to deal with law enforcement in Florida, law enforcement in South Carolina, also law enforcement in Colorado. And what this also tells me that you're also going to be dealing with a lot of cell site and cell phone data that has to be presented to the jury because there has to have been some link to be able to trace that the body is in Florida. So what you'll need in this case is a prosecutor who is very organized to keep everything in order, but also be able to explain it and deliver it to a jury so the jury can understand in layman terms what actually happened in this case and why this woman is guilty of stabbing and killing an 11-year-old child.
Jeffrey Wolf, let me ask you something. Take us behind the curtain for a second here. She has told a couple different stories, allegedly, right? Let's say you, as the defense attorney, you have your conference with her, and she tells you a third story. How does that analysis go in terms of what the arguments are that you make or what evidence you pursue, and you know, what you're going to tell this jury ultimately if you're getting all these conflicting versions of what took place?
Right. Well, the old adage is you can't ride two horses, right? So what you need to do is you need to evaluate, you need to track down the different stories that you're being told, if there are different stories that are being told at this point, or whether she's settled on one version of events that is her truth that she's living in. And you got to ride that horse. And you got to ride that horse hard. You can't throw a bunch of different things at a jury. The DA's office is obviously going to play up the inconsistent statements. But at some point when you get in there, you got to have a theme of your case. You got to have a story that you're looking to tell. And you have to stick with that one story and move forward.
All right. I'll be fascinated to see which one it is. I think everyone will be. And in that other case that we were talking about before, we didn't learn the story until opening statements. So we'll see what happens here. When we come back, we're going to take you to Tennessee. Police officer, former sheriff's deputy, charged with 44 counts in the indictment, things like sexual assault, stalking, extortion, horrible stuff. We'll give you a preview of that trial coming up.
Welcome back to Court TV Live. I'm legal correspondent Julia Janae with your Court TV legal news break. We begin with new details in the Breonna Taylor case in Kentucky. 3 grand juror members are filing an impeachment petition to have the Attorney General, Daniel Cameron, removed. In the affidavit that was filed today with the Kentucky House of Representatives, those jurors allege that Cameron misled the public about the case and the grand jury's role in it. They took issue with how he made the public announcement about the indictment back on September 23rd. Take a listen.
After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankinson for 3 counts of wanton endangerment.
Now, the grand jurors say that Cameron didn't give them an option to indict on other charges relating to Breonna Taylor's death, presenting them only with the low-level felony of wanton endangerment against Officer Brett Hankison. That petition alleges that the Attorney General engaged in, quote, misdemeanors, including the incitement of insurrection, breach of public trust, and failure to comply with duties imposed on him as the chief law enforcement official in the state. These 3 grand jurors remain anonymous. Their decision back in September cleared the 2 other Louisville Metro police officers who fired the fatal shots into Taylor's apartment. 26-year-old Taylor was killed in March while police were executing a no-knock warrant. Now, this all comes just one day after Cameron announced he is forming a search warrant task force through his office. This team is going to conduct a, quote, top-to-bottom review of the search warrant process there in Kentucky. It's a move that follows sharp criticism of how the warrant on Taylor's home was secured and reviewed. Cameron's office, in a statement yesterday, called his task force the fulfillment of a promise he made to develop best practices for the safe execution of warrants. And a historic multi-million-dollar settlement in Michigan is one step closer to approval in the Flint water crisis case. A federal judge has granted preliminary approval for the $641 million settlement. The U.S. District Judge Judith Levy signed off on the agreement in a 72-page opinion. That money is earmarked to benefit the thousands of Flint residents who were harmed by lead-contaminated water. Experts say that contamination led to an outbreak of Legionnaire's disease and led to at least 12 deaths in the area. The majority of that settlement, $600 million of it is going to come from the state of Michigan. Back in 2014, then Governor Rick Snyder and regulators approved the use of the Flint River without first treating the water for residents. Snyder was charged with 2 misdemeanor counts of willful neglect last week. On Tuesday, he argued that those charges should be dismissed because they were filed in the wrong county. Live in the Court TV newsroom, I'm Julia Janae with your legal news break.
On the docket tonight, a case involving a sheriff's deputy accused of 44 different crimes. Unbelievable stuff. It's out of Tennessee. Julie Grant has the story.
This shocking search by a Chattanooga area sheriff's deputy was caught on dashcam video last July in Hamilton County, Tennessee. 2 motorists were stopped by the deputy for an alleged traffic violation. Footage shows Daniel Wilkey and another deputy involved in the strip search of a man on the side of the road. Wilkey allegedly performs an illegal body cavity search of James Myron Mitchell.
This is one of 8 cases that I have involving Mr. Wilkey and then a variety of co-defendants. Common defendants in all those are Wilkey and Hamilton County government.
Daniel Wilkey has been hit with a 44-count indictment related to his actions against suspects he stopped for minor offenses.
Those counts range from rape to reckless driving. In there's reckless endangerment, sexual battery, stalking, and multiple official oppression, official misconduct.
Wilkey is being sued for allegedly using excessive force against Mitchell. As a result of the search captured on this video, he required treatment for anal contusions and surgery on a previously untreated hernia.
With these cases, particularly with James Mitchell, we're alleging that there's a history, if you will, of this type of misconduct that is condoned by the Hamilton County government through its sheriff.
Mitchell's lawyer says this is the tip of the iceberg of a much larger problem in Hamilton County.
We've got officers that have not only injured people or allowed to remain on duty, but also killed people. And until there was pressure from the local NAACP and black ministers here, no action was taken.
Wilkey is also named in a wrongful death lawsuit of a man he shot while on duty for the Ray County Sheriff's Department.
And it was, even though he was cleared, and that's one of the targets of my discovery in this case that we're going to probe, is what occurred there. He shot a man in the head at point blank range at a hospital when this guy was being taken to the hospital for some type of treatment.
Wilkey resigned from the Hamilton County Sheriff's Department in December of 2019. Court TV reached out to the department and they did not wish to comment on the matter.
Roadside strip search, body cavity search, this is beyond. Let's bring back in our think tank. Nima, it's always challenging for prosecutors when police officers are defendants. But then I look at, 44 charges. I mean, have you ever seen a jury come back and say not guilty 44 times?
I have, and jurors love law enforcement, but that's not going to happen in this case. There's so much video evidence against Wilkey. There's so many different cases. And I got to give credit to those civil attorneys, right? Because Hamilton County, they were asleep at the switch. He was sexually assaulting, physically assaulting everyone from men, women, underage children for more than a year before, Hamilton County sheriffs did anything, before any charges were brought. So, give credit to the NAACP, give credit to those civil attorneys for really pushing this case forward. He had problems in neighboring Ray County, but really Hamilton completely dropped the ball. I don't expect to have any issues getting a conviction in this case, regardless of how much jurors love law enforcement, because of all that great video evidence we have.
Yeah, Jeffrey, this is a case where with all the charges and all the accusers and alleged victims who are going to come into that courtroom, it's going to be difficult, I think, to overcome all of that. When it's a police officer and it's one incident and you're focused on what happened there, I think it's a whole different story.
Yeah, I agree. I think that when you're looking at one incident where you're able to say, how could anybody put themselves in that officer's head and know what was going through that officer's head in that moment, whether it's, a case of an officer driving recklessly or, God forbid, shooting somebody or something along those lines. But what we have here is we have so much. And as was just said, the video evidence, I mean, I don't know that there's a circumstance where it's not going to shock the conscience of a jury to watch a police officer bend a man over on the side of the road and conduct a full body cavity search on the side of the road. The indignity of that, the cruelty of that, the inability to do it with any sort of sanitation. This case really shocks the conscience.
Yeah, Bernard, I've talked about this story in this case with police officers and former police officers, and all of them are like, no, that's not part of the job. We don't do strip searches on the side of the road. We don't do cavity searches on the side of the road. This is just not normal.
Yeah, and it's so sad because this police officer, former police officer, is the same type of police officer that actually creates the distrust in police officers in the community. This guy is the type of guy that makes police officers look bad. For this guy to have carried out all these actions for so long, and I'm sure the people that he was targeting was African Americans and other minorities, it's a shame. And I don't know who empowered this man to think that this is what he can do, because it took so long, a year, for anyone to even mention what was going on. If it wasn't for the NAACP, would we even know what was going on with this officer? Would this officer still be on the force? What I'm curious to see is if the federal government is going to step in and also open up an investigation in this county to see if there's a history, if other people on the force knew about this and never said anything. So I'm curious to see if the feds are going to step in.
And of course, Court TV will continue to track this trial as well. We've got a date coming up in March 23rd, a status hearing. And I'm sure at that hearing we may get indications of what the trial date will be. We'll keep an eye on it. When we come back, time for our 13th juror, and a really difficult story out of New Hampshire. It's a love triangle, but it's difficult to describe because of what happened in this case. But we'll get to it when we come back. I'll gather my thoughts.
After driving Jonathan's body nearly 200 miles north of the crime scene in Jonathan's own car, deep into the North Woods, the defendant decapitated Jonathan, wrapped his head in a tarp, and placed it in a grave.
Not only had she been threatened with a gun in her mouth and beaten severely and ordered by Armando to participate in this conduct of destroying evidence, concealing evidence, depending on what aspect of it you're looking at. Armando, in fact, had access to her daughter and later did have custody of their daughter. So beyond fearing for her own life, even after she was left alone, she had no idea what else he was going to go do.
All right, those are the lawyers arguing in court in what I'm calling the gruesome love triangle murder case. And you're looking at, this is Brittany Barron. Now, if you look at the picture on the left, this is Brittany Barron when she is married to a man named Armando and is having an affair with a man named Jonathan, allegedly. That picture on the right is after her lover is killed by Armando and after she had allegedly cut his wrists while he was alive, but before he was shot, and then decapitated him after he was shot and was dead. Now, she claims that she was beaten by her husband Armando and forced to do all those things. So I posted this story on social media and asked the question, and it's not an easy one. This woman, Brittany Barron, is she a criminal or a victim? A criminal or a victim? You saw the pictures. You kind of know the story. This is a tough one for everyone involved. And investigators are conceding that she was beaten by her husband. They've conceded that in filings. All right, so we begin with our 13th juror comment of the day, coming from Carol tonight, who writes, absolutely a victim. Having an affair may not be morally right, but she was not happy in the marriage. But everything that followed is horrible. She was frightened of her husband, and the husband is truly an animal and went crazy. He forced her to do those horrendous acts as punishment. It is sick. She's been charged with falsifying evidence. He's been charged with the murder. They're both locked up without bond right now. Bernarda Villalona, what do you think? Is she a criminal or a victim? How do you see it?
So, Vinny, it's a tough case, but I can tell you, having tried homicides, prosecuted homicides for 10 years, that unfortunately you run across a lot of these cases where a woman is a domestic violence victim and she does do certain criminal acts as a result of duress. But like you can see in this case, the prosecutor already did the investigation and determined that the homicide itself, that whatever assistance she provided, she was acting under duress. She was a victim. She was forced to do this. She was in fear of death, of serious bodily injury, as shown all over her face. And thus, that's why they're not prosecuting her for the homicide. She is only being prosecuted for the falsifying evidence. Because at that time, even though she was acting under duress for the homicide, when she was trying to hide the body, the torso of this man she was having sex with, at that time, her husband was not in the area. She was caught by herself with the body, with the car of the deceased.
And a cell phone. Warren writes tonight, this doesn't matter. She still participated in the murder of this man. She should be punished, put to death. She knew exactly what she was doing. Jeffrey Wolf, how do you see her, as a criminal or a victim?
I see her as a victim. We're really screaming for the death penalty tonight on the show. It's really troubling. But ultimately, at the end of the day, that you don't do what is going on her face to yourself. And when somebody savagely beats somebody like that and participates in this grisly murder the way that her husband did, to say that she, like we just said, she was acting in duress. This is not somebody who had a choice of what was going to happen here. She likely would have been a second body next to her boyfriend's if she hadn't at least played along in some fashion. She's a victim.
Daryl tonight, she was a victim of domestic violence and forced into doing the horrific acts that her husband demanded she did. Nima, how do you see her? She was in that car by herself with a cell phone for 3.5 hours.
Yeah, she's a participant and a victim. You can be both. You know, she's a victim of domestic violence. They're not charging her with murder. But the real victim here, Vinny, is Jonathan. Why isn't anyone talking about him? He's savagely beaten and shot, and she participated. So you absolutely cannot give her a walk. What she's getting is an early Christmas gift. She should absolutely take that deal. And as far as death penalty, yeah, Armando, what he did, that should be a capital case.
Philip tonight, 100% criminal. She likes to blame someone else for her actions. Bernarda, does she end up being a witness, do you think, in the husband's trial?
Absolutely. I think that the prosecution already made that determination because they need her in order to prove the man's guilt. If not for her, they do not have sufficient evidence to show that her husband was the one who killed her boyfriend. So that's why they have to use her. They have to make a deal for her to testify against him. They need her.
Kylie, tonight, this is a tough one, but if she did this fearing for her life, she's a victim. No one would voluntarily do something this gruesome unless they were mentally unstable. We have about 20 seconds here. Jeffrey Wolf, are you surprised that she's being held without bond?
I am extremely surprised she's being held without bond. She has a child, and as everyone has pointed out, she is not charged with the highest crimes in this case. It doesn't smell right to me. I think they're doing it to put the pressure on her to get the type of testimony that they want to get and the type of plea that they want to get. It's been mentioned over and over again. Prosecutors love to hold things over people's heads to get what they want, and that's, I think, what they're doing here. I don't think she should be sitting in custody.
All right. Incredible insight tonight. What a panel. Bernarda Villalona, Jeffrey Wolf, and, of course, Nima Romani. Thank you all so much. Please come back soon.
Thanks,
Vinny. See you soon.
Thank you, Vinny. Good night, everyone.
All right, folks, that'll do it for us tonight. Remember, we are here Monday through Friday, 8 to 11, doing what no one else is doing, taking you inside the world of crime and justice. I'm Vinny Politan. As always, have a great weekend, and don't forget to hug the kids.